Good evening, ladies and gentlemen, our esteemed viewers at home. We welcome you to another edition of Democracy and the Rule of Law, a show where we delve deep into the critical issues of law and politics and governance. In today's episode, we'll be looking at two very important issues. Domestically, we'll be looking at the issue of Senator Natasha Abosi, of course, who her 6 months suspension from the Senate has elapsed, and she has written to the Senate for resumption. Of course, the clerk of the Senate has replied that the case is still ongoing in court and there is no green light for her resumption yet. So, of course, so many legal commentators have frowned at that, stating that that is a breach of her constitutional right, that she was elected by the good people of Kogi State, and that the Senate suspension is a breach to her constitutional right and a deprivation of the right to representation of the good people of Kogi State. So we'll look at the legal consequence of all of that. And of course, on the foreign scene, we'll also be looking at the issue concerning the detention, prosecution of the self-acclaimed Prime Minister of the Biafran Republic, Mr. Simon Iwa, who has been convicted for inciting violence by the Finnish government. Of course, we'll look at it vis-a-vis of Nnamdi Kalu, who has been incarcerated, awaiting, of course, the trial has been going on for almost 8 years now. There has not been a conclusion of that trial. We saw how swift the trial of Simon Ekpa was, and he was quickly convicted for inciting violence and terrorism charges. So we'll look at all of this. Of course, we'll see how the course of justice compares with Nigeria and foreign jurisdiction. These are the two topics we'll be looking at today's episode. Of course, we apologize for starting a bit behind schedule. We had some technical issues we had to fix. That was why we started a little bit behind schedule, and we are very, very sorry about that. We'll go on a very short break. When we return, we would introduce our guests who are already seated in the studio this evening to help us look at these two issues that have been enumerated. Stay tuned, we'll be back very shortly. If you are just joining us here on your favorite program, Democracy and the Rule of Law, with me on the show this evening is Barrister Obiora Ome. Barrister Obiora, welcome you to the show this evening.
Thank you very much, and good evening to our esteemed viewers out there.
And also with me is Barrister Michael Mona. Barrister Michael, welcome you to the show this evening.
Good evening, viewers.
All right, without wasting much of our time, we will quickly delve into the nitty-gritty of today's episode. Of course, we'll look at the issue of Senator Natasha, who, in her bid to return to the Senate, has been met by a roadblock. Of course, the clerk of the Senate have written that she does not have the green light to resume yet, citing some issues concerning the cases that are still pending in court. So what do you have to say about that?
Well, it is clear and very obvious that the upper chambers appears to be going outside the perimeters of rule of law and democracy. Starting with the episode when Natasha observed that there were issues in the Senate, what did she do? She proceeded to court to ventilate her grievances and ensure that her rights were fully observed and respected by the upper chambers. She proceeded to court, filed suit against the upper chambers. And what happened? The upper chambers was duly served, and they participated in the proceeding, which is still ongoing. And in the course of it, the Senate went ahead and, in clear violation of the principle of law, that once a matter is before a court of competent jurisdiction, parties are expected to allow the court to decide that matter, which is an age-long principle of law propounded in the case of Ferguson and Daniel, that once a matter is before a court, the parties must not take any action, particularly if an injunctive relief is sought in that suit. Natasha, in her matter before the court, sought for declarations and injunction. But notwithstanding the pendency of that case before the court, as well as the interim order that was granted in her favor by the court, the Senate proceeded and suspended her. And the law is very clear that even if there was no order of injunction granted, the mere fact that she has gone to court, and among the relief she is seeking in the court is an order for an injunction against the threatened violation of her rights. The other party, which is the upper chamber, is expected to wait without taking any action against her. But alas, they proceeded and suspended her. Of course, this principle of law, which has been there over the years, happened in the case where a man got information that he was to be served sermon on a Monday. He got that information on Friday, though he had not been served, and that had to do with land disputes. He had to engage a lot of workers. They put up the building. By the time he was served on Monday, he had completed the building. And he went to the court and informed the court that it was too late for the court to grant an injunction because the building had already been completed. And when the court became aware that he had notice, even though he had not actually been served, of the summons, the court made an order that the building be put down, because it was put up in clear violation of the law that once a party has run to court, you shoot your dagger, put your sword in its sheath, and await for the court to decide, so that you don't foist upon the court a situation of helplessness where the court will be incapable of making an order because one party has overreached the other party.
All right.
Now, coming home to Natasha's case now, they decided to suspend her, notwithstanding the pendency of that case. Now, Natasha complied with the suspension, which of course some of us view as unconstitutional, as irregular. And the suspension has now been spent. They are now going back to say, well, there's a matter in court. Whereas they ought not have suspended her because of that matter. Now that they suspended her without reference to the pending matter in court. Why would they now turn around to say there's a matter in court? That is analogous to approbation and reprobation. And they appear to be speaking from both sides of their mouth. You cannot ignore the proceeding to the court and issue suspension, and that the expiration of the suspension period say, no, there's a matter in court. That's approbation and reprobation, and the courts of law will not and can never tolerate such brash violation of constitutional rights, bearing in mind that the matter does not just concern Natasha per se. It has to do with the right of right of constitutional representation by a senator. She has a constituency she represents, and those people for the past 6 months do not have their rights being their rights to representation. It has been in abeyance for over 6 months. That is unacceptable. That's unconstitutional. That is a clear confrontation with the sacred principles of democracy and rule of law.
All right, Barrister Michael Mana, does the Senate even have the right to? Because from the way this is going, it seems that the Senate have the right to perpetually suspend members who have behaved in a very, very shameful and way in court.
There's nothing like that. There's nothing like the suspension in perpetuity. You see, this Natasha issue, my colleague has stated the background, given the background. What he has not told us is that the matter was actually decided by the High Court. Now it's on appeal. The two bodies appeal against the judgment. Natasha appealed, the Senate appealed. Now, if there is an appeal like that, it is immaterial. Even if the matter was in the High Court and the suspension had been spent, they should have allowed Natasha to return to the Senate. It is immaterial that one of the prayers, one of the reliefs sought by Natasha was that the suspension was illegal, which the High Court refused to pronounce on, and that made the Senate, the Senate emboldened the Senate to continue in this kind of illegality. There are some other decisions that had decided that the Senate does not have the rights to suspend somebody beyond a particular number of days, because this person does not represent himself. He's representing some constituent, as my colleague said.
And his actions, those his constituents are going to bear the brunt of his actions.
Yes, they are the ones that will bear the brunt
of his actions.
So if the Senate had that kind of constitutional right to suspend in perpetuity, then there would have been no need for somebody to even say that he is contesting normally to be elected. The Senate does not. It is only if you appoint somebody that you have the right to suspend and also remove, according to our own judicial authority.
Yeah, but you said that the court refused to pronounce that the suspension was illegal in the first place.
It is one of the issues that Natasha has appealed against to the Court of Appeal. It is the Court of Appeal. But the issue of saying that because the matter is in the court, and so Natasha should not return to the Senate is an issue that is beyond rhetoric. In fact, it is something that I feel the Senate is actually sitting on the right of Natasha. And it is not only Natasha, the Senate is sitting on the right of the constituents that Natasha is representing. And I think it is something that the entire Kogi, is it not, or ways that Natasha is representing, should rise up to enforce or to ensure that Natasha returns to the Senate. What the Senate has done is not right. It cannot be right because the Senate suspended Natasha. Natasha has served the period of the suspension. Now, why are you still saying that she is still on suspension after the expiration of the period? There is no rule that says that after the suspension you have to come back and apply or comply with some. The suspension was not conditional. Yeah, there was a time that the Senate actually said that if she apologizes, she will be recalled. She did not apologize according to them because she made some publications where they said it was not did not meet their own specification of apology, and so they refused to recall her. She has spent the 6 months. Recall her, allow her to. In fact, it's not even a matter of saying recall her. Let her come back. She has the right to move into that Senate as a matter of.
But you are saying that the jurisprudence we currently operate do not allow elected representative to be suspended, and we could see an executive governor being suspended in River State for 6 months and could even have been extended for another 6 months.
That we have discussed here.
But that is also
the illegality of that emergency rule. What else to go through it again?
There's no court that have pronounced it that. There's no court that have pronounced it that is illegal.
Well, the court has not pronounced about this emergency rule.
Yeah, no court have said that it's illegal.
Because nobody has gone to court.
So the PDPs went to court. It has been in the Supreme Court. They refused to hear it.
The court did not hear.
But the Supreme Court is still going to hear it.
After the suspension, that must have elapsed.
So, but you see, it is this kind of case is very important for the court to pronounce on, so that subsequently, even if after the present dispensation, the present president goes, if another one comes, you will know that the president has no power to suspend somebody that has been elected, just as he was elected into office. So it is not an issue of saying because it is spent. That one, if this Natasha issue, if the Court of Appeal holds that she was wrongly suspended and then she should be reinstated, you know that whatever there's no doubt that she had actually spent the 6 months, she will be entitled to all the benefits accruable to her.
I'm sure that wouldn't have been a problem. That would not be. If they can keep her away for the next 2 years and pay her off, I think that would be very.
There are so many issues.
Because of course the payment shouldn't have been issued.
Yes, they can afford to pay her double.
Exactly.
And just do away with that. The area I also want us to just take a cursory look at is that one, yes, at the time the High Court decided the matter, the issue that people were looking at is the need for certainty in judicial judgments and orders. That the judgment was not very certain as very clear. But one thing is very basic and very clear. And what is that thing? That the court did not say that she should continue in suspension. Mm-hmm. The court said that she had to pay a fine and then be called back. But then the language the court used was what people say was kind of persuading or appealing to the Senate to allow her something.
It was not an order.
What people expected that an order, but even then, so long as the court has said, okay, pay fine, that ends the matter. There's no order reading into it as if she had to continue in suspension, in the illegal, unconstitutional suspension. To that extent, the judgment of the court is very clear that she does not need to continue in suspension. That was why the court said, pay fine and go back to the work. Right. So in that case, there is no the fact that for purposes of clarity, ex abundante out of excess caution, to be sure that everything is clear as crystal, the counsel to Natasha appealed so that it would be boldly written that
to show that the court wasn't clear.
Stop her from going back to the upper chambers to continue her business.
Yeah, because
of legal representation.
The Senate is saying that the case is still pending now. So by implication, there is a renewance of our suspension until the case is dispensed in the Court of Appeal.
The Senate appealed because by virtue of that, the court said, pay fine and go back to your work. So they felt that that does not meet with what they wanted, because they wanted to punish her unnecessarily outside the parameters of the law and the Constitution. And that is why this program, Democracy and Rule of Law, will come out and say, look, this step is unconstitutional. It's an attempt to strangulate the rule of law. Yeah, it's an attempt to bury democracy. It's an attempt to get the society to conform to what is properly unacceptable in other jurisdictions.
Yes, sir. It is very commendable that individual comes out to say that these things are unconstitutional.
Yes.
But there are institutions of government who are supposed to say that these things are unconstitutional and enforce it. And when these institutions begins to keep silent, we've seen what has happened in the River State. The Supreme Court have refused to pronounce on it. It has elapsed. Natasha's own has elapsed. Another 6 months have started reading. And the court, how many days does it take to pronounce on these things?
That's a side reminder once again of what we have said over and over, that in this nation, there is the urgent need to separate the office of the Minister of Justice of the Federation from that of the Attorney General of the Federation. Because the Attorney General of the Federation, by virtue of his office, is to defend the Constitution against violation either by the federal government or any state government or individuals. In cases like this, the Attorney General of the Federation is supposed to come out and tell the Senate boldly that what you've done is an infraction of the Constitution and the rights of the people. But because we have one person occupying that dual position, because the Constitution, Attorney General of the Federation as an office, and then the Minister of Justice. In a normal society where that office is separated, this is a matter that the Attorney General of the Federation is capacity as the defender of the Constitution has to come out and tell the Senate and those involved that what you've done is an infraction of the law and you have to halt it.
Yeah, but the court,
I don't think
the court is there. This is a civil matter,
the Senate has done. And what I feel the Attorney General should do in the circumstances is to approach the court to pronounce on the issues, not combining the offices, as you have said, of the Attorney General and the Minister of Justice, because the Minister of Justice is a politician.
Yes.
Attorney General is a professional
who
is supposed to be employed, who is supposed to be the civil service, who is supposed to represent the people. But the minister who is an appointee of the president and is supposed to be loyal to the president, whatever the way the president sees things.
Yes.
So we have been advocating that the office of the Attorney General and the Minister of Justice should be separated.
Yes.
Even at the state level, the Attorney General and the Commissioner for Justice should be separate entities.
Yes.
So that the Attorney General will do his work as a professional.
Yes.
And then the Commissioner or the Minister will be a politician that he is.
And be loyal to his
appointees to the core. Because if you are not loyal to your appointee, you will be sent home. But the thing is, if this issue is in court as it is, does the Senate have the right to keep Natasha out of the Senate chamber? The answer is capital no. The Senate has no right whatsoever to keep Natasha out of the Senate chambers. The fact that they appeal against the judgment of the court that actually said Natasha should return is immaterial, because Natasha has spent the period that she was suspended. There's no other order of the Senate or from the court that is suspending Natasha. And so if anybody stops her from going into the Senate chambers, that person will be violating her own constitutional right, and she has the right to approach the court to pronounce on it.
Yeah, but she has approached the court. So do you think that the court is the issue in all of this? Because obviously we won't blame the court is there to ensure that there is settlement of dispute between these arms of government or between ensure that people's rights are protected. But when the court continues to dilly-dally on these critical issues, you have seen that it has taken 6 months.
Yes, that is what I'm saying now.
Because you said that she is supposed to go to court to go and protect her right, but then
if they stop her,
she has gone, and they stopped her, exactly.
She is ordinarily, because she cannot force herself into the place. She has to do the civil thing, take the legal step by going to court to ask the court to to allow her to approach, to enjoy her responsibilities. But be that as it may, what my advice to whosoever is in occupation of that authority to allow her enter the Senate is that she should be allowed to resume work immediately. The Senate has no power on its own to stop her after the suspension. If the Senate feels that she still has some questions to answer, let them deliberate it on the floor of the Senate and then come out with the resolution, just as they did in the suspension, and they follow their own order.
Yeah, but the courts have not told them that they do not have any right to suspend her.
What I am saying is that this particular one that is now running, not the previous one. She has spent that previous suspension. But if
it has been renewed automatically. That's what the Senate. That's what the Senate is saying by implication.
No. It has not been renewed. You don't renew that kind of suspension by writing a letter and all that. It must be on the floor of the Senate before any action.
No, but for them not to allow her to resume, means that they are saying, they don't need to say, come out and say, they are saying that the suspension has been renewed by implication.
But
Because that is what it
there
means.
is no basis for that presumption, and I can tell you why there is no reason for that presumption. First, the first 6 months of illegal suspension, which is what I call illegal suspension, has been spent. That 6 months has expired. Now, Natasha not being allowed to be part of the proceeding for the past 6 months was predicated on that suspension.
Exactly.
Now, as at today, is there any basis for her not to be part of the proceedings in the upper chamber? The answer is capital no. The reason is this: by virtue of the judgment of the lower court, she is free to participate in the proceedings of the upper chambers. And the only thing that can stop her is if an appellate court has given an order either staying that judgment of the lower court or granting an order staying that judgment. But as of today, there is no order of execution staying. There's no order saying the execution of the judgment of the lower court. To that extent, the road is very clear for Natasha to go to the upper chambers.
Yeah, but
there's nothing stopping her. The suspension has been spent in terms of the number of months given, and that has been done. And there's no other instrument, no resolution by the Senate. And of course, once a court of law has given judgment, whether you like that judgment or not, what is the law? You must obey that judgment or order of God. So it does not matter. Now, what is the way forward? The way forward for Natasha to go to the lower court and take proceedings, initial proceedings to commit those involved to prison for contempt of court. That is the way. Serve them from 48. Notice of the consequences of disobedience of court order. And after 48 hours, proceed for committal that this is the judgment of the court. And they have refused to comply with that judgment.
For the judgment that she herself have appealed.
No. She appealed not against the entire judgment. She don't appeal because if you look at the notice of appeal, they said part of the judgment appealed the case. It is just one portion that the court did not make a pronouncement on the legality or otherwise of the suspension. But that is not the entire judgment.
Natasha also appealed against the aspect of asking her to pay fine to the Senate before returning. And that was predicated on the fact that she was to return. If she were to return before the expiration of the suspension period, she had to pay this fine. But since she had expended the period of suspension, she is no longer required to pay the fine. Then you see, because
the court had presumed that the suspension was legal in the first place. If the court has predicated as her return on the expiration of her,
there were some issues that arose that made the court.
Because the court never pronounced that her suspension in the first place was illegal. If they pronounced that it was illegal, she wouldn't have been asked to pay a fine in the first place.
The reason for the fine was that Natasha was supposed to have made some apology to the district, which she made some things that were said to be offensive to the Senate. And that was why, in the wisdom of the court felt that she should pay fine because of that, and then go back to the to resume her duties. But be that as it may, all these are semantics. What we are saying now is that the period had expired. The period of suspension had expired.
Yeah.
Natasha has the right to return to her duties.
Because there are no other suspension.
Yes, she's no longer under suspension.
But now that she has been refused to resume, what do you think that she's doing? She have to go to court and wait for another 6 months for the court to give her
apply for
and what does she have to do?
For committal. Committal to prison.
Well, I don't look at it as application for committal to prison is a proper reason, because since the court, there was no, she did not pay the fine and all that to return. If she had paid the fine and the court, the Senate refused to allow her to return, it would have been a different thing. Now, the court did not say anything about the issue of waiting until the suspension elapses. So that is why I'm saying that to commit them for disobedience might be difficult because the matter is on appeal. But once you go to the lower court now to ask that they suspended me for this period, you are not going to ventilate many other issues. They suspended me for this period. I have served the suspension. Now I want to go back. They refuse. They don't allow me. I want this court to honor that I should be allowed to go back to my duties.
You see, in as much as I agree with what you say, but there's this aspect that you have not, really adverted your mind to. And what is that aspect? One, that the Senate appealed because they knew that by the totality of the judgment of the court, that Natasha is free to return either at the expiration of the 6 months or on payment of the fine which the court imposed. So whichever way it goes, that the road is free for her to come back.
Yeah, but the question is, if the court has not pronounced that suspension was illegal in the first place, it means that the Senate still reserves the right to suspend her for that 12 months.
Now, but the question is, the law does not speculate. Speculation is under the realms of the law. What the law deals with the hard facts and evidence. After the first suspension, there is no other suspension in place. That is one. Two, the fact that the Senate appeal does not operate as a stay of execution. You can appeal 100 times if you want, but the order of the lower court must be complied with. But the only way to stop compliance if there's an order for stop execution, and that has not been. There's no order of execution.
Yes, but by Sobiom,
the appellate court or the law, and once appeal is entered, it's only the appellate court that can.
But Sobiom, without pronouncement on the legality or illegality of the suspension, it means that the Senate could still resuspend her tomorrow, right? Of course, if not pronounced that this suspension is illegal, that means if they go through the process they use in giving her the first 6 months suspension, he could still work again since there is no pronouncement on that. Then all of these things we are doing in court will be rendered not getting, because we are talking about a first suspension, right? Because now you are saying that it's illegal, but the court have not said that. If you can say that it is illegal, why is it so difficult for the institution that is paid to pronounce these activities illegal? Why is it so difficult for them to do so?
Well, that's what you are trying to do is to drag us into the realm of speculation.
Yes, why is it? No, we are not in speculation. This is fact. This is fact because
you know that there's no pending.
Because it was very, very easy for you to say that this is illegal. Yes, there was no ambiguity when you said that this suspension was illegal. Yes. So why is it so difficult for the Court of Justice, paid by our justices, to pronounce on this? Why is it so difficult? This issue has not been pronounced as illegal. That was the question.
Now, the court did not. The court on its own did not specify in its judgment say that the suspension was illegal. But a total and holistic reading of the judgment is clear that the judge wanted Natasha to go back and continue the representation of the constituents that she's under the constitution to represent. That was why the judge said, okay,
go back through the back door.
No, say back through the back door. The court said you should pay this
and resume.
And resume work.
Yes.
And they said no, we go on appeal.
So now they are going on appeal does not stop her from resuming.
Yes.
The only thing that can stop her is either there's a fresh suspension order, which of course they cannot do because.
So you are comfortable with the approach.
Or there's an order of stay in the execution of that judgment.
So are you comfortable with the approach the courts have taken in this matter, which has even made this ambiguity that she doesn't even know whether she should resume? The Senate doesn't know whether to allow her to resume. So are you comfortable with this? Is the law, ambiguous that?
I started by saying that the judgment, created little room for speculation, which of course is not the proper thing. Because if you look at judgments, of course, the judgments will be very clear, very certain, unambiguous. in a situation where after judgment has been delivered, both parties are celebrating their victory, you know that something is wrong somewhere. That they will look at it and say, yes, we have won, we have won. So in this one, maybe it was an oversight on the part of the judge,
Could it be an oversight?
or that the judge does not want to step on big toes. I wouldn't know. But what I know is that a total and holistic reading of that judgment shows only one possible outcome. And what is that thing? Natasha, pay fine, go back to resume your work, parties, Senate, don't hinder her from resuming her work. Please don't hinder her. Which people are interpreting to me the judgment is persuading or appealing.
So, don't you think that this type of judgment are a threat to our democracy? This type of ambiguous judgment.
You have said it all. It's a threat to our democracy. And that is why I have been appealing to our judges and judges. Once you know that an issue has come before you that is going to affect the fundamental of our existence, it is important to take time, go through the issues very well, align them with the legal issues before you make the pronouncement. I have had situations that I obtained judgment from the court, and at the end of analyzing the judgment, I really sympathize with my client, and the other party equally sympathize with his client, because we could not harness what the judgment actually said, mixing up everything together, and then the burden is down for you to go on appeal. And we know what appeal means in this nation. You go on appeal and stay there for years. In fact, I just lost one of my clients last week who finished a matter in the National Industrial Court in 2019, and we appealed against the judgment because we were not contented with the content. And then the matter had been there since 2019 till the man died last week. 2019 till the man died last week. Now, what the next available thing is for us to withdraw the appeal. The man is dead. And it's so unfortunate because if you have to look for a way to say you want to substitute now, going through the same procedure again, you know the number of years it will take you to rewrite. We had done everything, both sides. Appellant and respondent had filed their briefs. It was just for the court to hear the matter, and the man died.
But if the matter survives your client, you can substitute and
it's the substitution, the process of substitution that we are talking about.
You can still do it at the appellate court.
The process, the time.
It's in the court of appeal that the matter is.
You can do the substitution there.
I know.
Then you have already evidence that the man is gone to.
If this matter had gone through this period, you understand, you are going to substitute. And once you substitute, you are bringing another party, you understand, who is going to be acting as the appellant.
Yes.
In the place, you understand?
And
it takes, I know,
so
it takes time
to exchange briefs and all of those things.
But is it not better to do that than to allow the injustice which you wanted to cure to continue in perpetuity? Delay is not denial.
Some of
I agree that
delays are denial.
Yes, the man has gone to heaven or wherever he may be now. Crying that he was still expecting the court of appeal to give him judgment. Yeah, yes, but that is part of what we are still saying that
because that is the same thing that has happened with this River State issue. We've not been able to pronounce on it, and the state of emergency will be ended on September. In fact, they are even started doing Thanksgiving on 18th. And the court has not even heard the case that has been filed by the PDP governors over months ago.
And that brings to the fore once again the issue of delays in the administration of justice in Nigeria, which is one of the strong obstacles to justice delivery.
Because in other foreign jurisdictions,
in relation to Natasha's case, I know that Honorable Justice Chukwudi put of the Supreme Court of blessed memory, has a lot of cases giving out the data, the proper constituents of a judgment. One, that the judgment must touch on the subject matter, the controversy between the parties. That the judgment must resolve that controversy one way or the other, and it must be certain, it must be clear, it must not be ambiguous, it must be precise. That is one of the things, the nebulous part of the judgment that made Natasha to decide to go on appeal. But on the whole thing, we are saying that there is need for us as a nation, for the sustenance of our democracy, rule of law, and the entire organogram of this nation, that we need to have a total review overhaul of the justice system administration in Nigeria, so that those hindrances, those things that cause delays in justice administration will be done away with. Is it that we lack manpower?
Perhaps.
Is it that we don't have enough hands? There are many Nigerians who are ready, willing, and able to get there, either at the Supreme Court, Court of Appeal, and the lower bench, to handle matters, so that Nigerians will no longer see the court as a place where you go and waste time. Because that's what makes some people, that when there are issues that may take to court, they say,
Go to court.
They know that how many donkey years will it take.
Some people don't even want to go to court again.
Yes.
And the other party will be telling you, go to court. Because he knows that if you go to court, you will stay there forever.
Yes.
And this is not right.
It's not good for our nation at all. It's clearly against the tenets of democracy and rule of law, both in this nation and other jurisdictions. And that is why cases linger so long that people lose hope in the process.
All right. So we are almost out of time. I will not be able to take the second topic. Perhaps we'll take that next week, subsequently. So we'll just take your last one, because we just have less than 2 minutes to wrap up.
Yes. As far as the Natasha episode is concerned, legally, there is no thing hindering her from resuming work at the upper chambers, because the only known suspension has been spent. So there's no other suspension issued against her. Secondly, from the judgment of the lower court, she is to resume at the upper chambers. And the Senate has appealed against that judgment, but there's no order stating the execution of that order of the judgment of the lower court. To that extent, the course is clear for her to resume. And unfortunately, when she proceeded to resume, she was hindered.
Right. But
which is unconstitutional, and she can take steps to enforce the judgment.
All right, Mr. Mike, let's take your last.
My advice is that the Senate should allow Natasha to resume.
So that does not translate to withholding. Yes.
Okay. All right. This is where we draw the curtain on today's episode of Democracy on the Rule of Law. Catch us same time next week as we look at more trending issues. Stay tuned to meet again next week.